Good afternoon, and thank you for joining us. We'll begin in just a minute. I'm Bonnie Patton, Executive Director of Truth in Advertising, or TINA.org for short. I have made my 3 college-age children leave the house so they wouldn't use internet bandwidth. I've banished our dogs to the barn, and I've closed the doors to our library to keep the cats out. So hopefully we should be good to go. For those of you not familiar with our organization, TINA.org is a nonprofit consumer advocacy organization that works to outstop and prevent deceptive marketing. We focus on advertising and marketing of all kinds and in all sectors of the economy. We publish consumer education and news articles on our website, and we pursue legal actions with self-regulatory bodies and with state and federal agencies. Today, we have the pleasure of hosting FTC Commissioner Rohit Chopra, who was incredibly prolific in 2020, publishing more than 50 speeches, articles, statements, and testimony, including 11 dissenting statements, 3 concurring statements, and 2 law review articles. One of them, the case of resurrecting the FTC Act's penalty offense authority, I think we may hear more about today, as Commissioner Chopra speaks about the FTC's remedial authority after AMG. For those of you who are not familiar with the AMG case, I'm going to try to provide you with a very brief, no doubt oversimplified version of the case, which starts in 2012 when the FTC sued Scott Tucker and his company, AMG Capital Management, among others, alleging that Tucker and AMG were basically payday loan sharks. 4 years later, 2016, a federal district court agreed with the FTC. It issued a permanent injunction, permanently halting AMG's legal lending practices and ordering it to pay $1.27 billion in restitution. AMG appealed that decision. It didn't dispute that it had violated the law, but rather argued that the money it took should be its to keep. And as crazy as that may sound, 2 federal appellate courts have recently ruled that AMG is right. Swindlers should be able to pocket their ill-gotten gains. And here's why. The commission sued AMG under Section 13B of the FTC Act, which says that the agency can obtain a permanent injunction, but it doesn't say anything about money. The right to claw back ill-gotten gains actually hails from the 18th century, when courts recognized that the authority to issue an injunction carried with it the right to make victims whole, because, as they said, the wrongdoer should not profit by his own wrong. And for nearly 300 years, this equitable principle has guided the courts. As for AMG, the Ninth Circuit, which heard its appeal, sided with the FTC, holding that the money should be returned to the victims of the loan sharking scheme. But the Ninth Circuit didn't get the final word. The Supreme Court is reviewing AMG, and it will hear oral argument on Wednesday as to who gets the money under 13B. Now, all of this is not to say that AMG and its supporters believe that scammers should be able to keep money they've stolen from consumers. Rather, AMG and its proponents argue that the FTC cannot use Section 13B to claw back ill-gotten gains. So if not 13B, then what? How does the FTC make victims whole? How does it deter wrongdoers and protect honest businesses? These are the issues that the FTC will be forced to grapple with if it does not prevail in the AMG case. So now that we're all up to speed with respect to AMG, it is my honor and privilege to turn things over to Commissioner Chopra.
Thank you, Bonnie, for that incredible introduction. And I want to thank you and the entire team at TINA.org for hosting this important discussion and for all the work that you do. This is a really important week for the FTC. Like you said, on Wednesday, the Supreme Court is going to hear arguments on whether Section 13B of the FTC Act permits the agency to seek refunds and monetary forfeitures from lawbreakers. And as we all know, Section 13B has been a bedrock of our consumer protection enforcement for decades. And I'm really grateful to TINA.org, my friends in the state attorney general community, and many others who weighed in on behalf of the FTC and American consumers. Now, I'm not going to comment on the merits of the case. We'll be able to hear about that in the oral argument in a few days. But I have been able to observe the effect of the uncertainty around this case on the FTC's work. More and more commissioners are hearing that the FTC should simply accept more weak, no money settlements due to the threats facing Section 13B. And clearly, there is a perception that this moment of crisis for the agency is also a moment of opportunity for those looking to evade meaningful accountability. This perception needs to change. And it is true that over the last 40 years, the FTC has relied on Section 13B to return billions of dollars to consumers. And let me be clear, losing this authority would be a big blow to families and honest businesses. But I also want to make clear that the Commission also has other arrows in our quiver to ensure that there is accountability for corporate fraud and abuse. So today I want to describe some of the tools we should resurrect and some procedural reforms we should pursue in order to rebuild and maintain our credibility in the marketplace. And I'm going to provide an overview of our authorities and describe a few of them in more detail: the penalty offense authority, restatement rulemaking, reforms to the Commission's administrative litigation process, and stronger enforcement cooperation with other agencies. And I'll close by arguing that regardless of how the Supreme Court rules, it is time to use these tools to ensure that we are systematically challenging and deterring market-wide abuses by powerful players rather than simply playing a game of whack-a-mole. So let me start by providing some more background in addition to what Bonnie shared on the FTC's various remedial tools, starting with Section 13B, the authority that's under challenge. Section 13B authorizes the Commission to seek preliminary and permanent injunctions in federal court for violations of the FTC Act, as well as other statutes that we enforce. And a large body of case law developed over the last 40 years has confirmed the Commission's ability to seek monetary relief under this provision, including refunds for consumers and disgorgement of ill-gotten gains. In addition to Section 13B, the Commission can seek monetary relief through Section 5L, 5M, and 19 of the FTC Act. Section 5L allows the Commission to seek monetary relief for order violations, essentially for repeat offenders. Section 5M allows the Commission to seek monetary relief for rule violations and penalty offenses, which I'll describe in more detail. And Section 19 authorizes the Commission to seek monetary relief for trade regulation rule violations and for dishonest or fraudulent conduct following an administrative proceeding. Importantly, a number of these tools allow the Commission to seek civil penalties. Now, civil penalties are very distinct from equitable relief available under Section 13B. Often when government gets a monetary judgment, people think of it as a fine, but it's important to understand the distinctions. Monetary relief under Section 13B is generally capped at a victim's harm or wrongdoer's unjust gains. That means when a corporation cheats families out of $1 million, the most they will have to pay if they are caught is $1 million. So it's not really clear that this is much of a deterrent. And the Supreme Court has in fact made clear that equitable relief is not necessarily intended to deter. In contrast, civil penalties are not at all capped at harm. Parties that violate a penalty statute or rule under the FTC Act are liable for up to $43,000 per violation per day, which is adjusted based on factors laid out in judicial decisions and in the FTC Act. This means that penalties can be significantly more deterring than equitable relief alone. And furthermore, while penalties are returned to the Treasury rather than victims, in my experience, many companies are willing to offer robust remediation for consumers in lieu of or even in addition to paying a civil penalty to resolve a matter. Identifying authorities that trigger civil penalties for violators is therefore a key part of rearming the FTC. That leads me to the first authority I would like to advocate greater use of, the FTC's Penalty Offense Authority. In a recent working paper, Samuel Levine and I argued the Commission should resurrect the authority under Section 5M1B of the FTC Act. Under this authority, if the Commission formally condemns unfair or deceptive practices through an administrative proceeding, other companies that commit these offenses can face big penalties if they knew the Commission already declared the conduct to be illegal with respect to another party. This is a very unique tool in commercial regulation. And resurrecting the Penalty Offense Authority offers a big advantage for the FTC. In key areas, the Commission can deploy this authority almost immediately. Because the Commission has long condemned illegal practices like income misrepresentations, fake reviews, and bogus medical claims, the Commission can trigger penalty liability by notifying companies that it is illegal to misrepresent income, generate fake reviews, misrepresent earnings, or otherwise engage in misconduct that the Commission previously declared to be illegal in a final Commission order. To be sure, this is not a panacea, and it is no substitute for Section 13B. And of course, the Commission will need to be strategic in designating penalty offenses that will be sustained in court. But there is zero downside, in my view, to incorporating this authority in a more routine way into the FTC's toolkit. For example, since the onset of the pandemic, the Commission has sent dozens of warning letters to firms making unsubstantiated health and income claims. By including penalty offense notifications in these warning letters, the recipients can face significant civil penalties for continuing in their violative conduct, making it more likely they will quickly come into compliance. And if they continue to flout the law, those companies may face significant sanctions. The Commission will also be in a much stronger position to seek monetary relief in litigation. I do think the Commission really must routinize use of this authority by including these notifications and warning letters involving conduct that could constitute a penalty violation. I next want to discuss restatement rulemaking under Section 18 of the FTC Act. Now, Section 18 allows the Commission to write rules prohibiting unfair or deceptive practices that are prevalent in the marketplace or where the Commission has previously issued orders condemning that conduct. These rules we have authority to impose specific requirements on businesses like issuing disclosures, but it doesn't need to. And in fact, restatement rulemaking is a different model. Restatement rulemaking simply codifies well-accepted precedent or guidance while imposing zero new obligations on honest businesses. Restatement rulemaking can complement the penalty offense authority, especially where there is well-developed precedent, but no litigated commission administrative orders. And restatement rulemaking, I believe, offers quite a bit of promise for the commission. First, it can increase recoveries from bad actors, as violations of these rules allow the commission to seek damages, penalties, in addition to redress. This goes beyond what the commission has typically recovered under Section 13B using equitable authorities. Second, rules give market participants guidance on where the commission draws the line when it comes to unfair deceptive practices, which helps level the playing field for companies who are not as familiar with FTC or with legal precedent in their area, or who simply can't afford the high-priced, politically connected lawyers that can save them when they violate the law. Third, rules can actually deter misconduct as they allow the commission to seek big penalties, around $43,000 per violation, wiping out their illegal profits and then some. And finally, and very importantly, because a restatement rulemaking would simply restate existing law or precedent, it would impose no burden on the firms already following the law. We have a clear template that we've established for this approach in our ongoing Made in USA fraud rulemaking. As many of you know, one of the commission's responsibilities is to ensure that firms do not abuse the Made in USA brand and label. They cannot slap it on products imported from overseas and parade their patriotism. But for decades, the commission responded to even the most egregious fraud with no money settlements. This enforcement approach has been a failure, in my view. Since I joined the commission, we have seen a number of cases involving blatant Made in USA violations, including by companies that had already been warned. It is clear to me that Made in USA fraud was not being deterred enough. But today, thanks to a proposed restatement rulemaking, the commission can change course. In 2019, TINA.org filed a petition for rulemaking with the commission, asking us to restate our existing Made in USA enforcement policy statement into a rule. The commission listened, and in June, we voted to propose to restate the existing Made in USA standard into a rule. And again, this rule, if finalized, would allow the commission to seek damages, penalties, redress, and more against Made in USA fraud, while imposing no burden on firms that have been actually making their products in the US and otherwise following existing guidance from the FTC. If finalized, the rule would turn the page on many of these no money settlements, regardless of how the Supreme Court rules on Section 13B. Now, many of you know that Congress granted the commission specific authority to write Made in USA rules using the Administrative Procedure Act, or APA, rather than the procedures set forth in Section 18 of the FTC Act. But I want to respond to the view out there that rulemaking under Section 18, that's sometimes referred to as MAG-MOS, reflecting the Magnuson-Moss law, is impossible. In fact, the commission routinely conducts rulemaking under Section 18 to update rules. And my colleague, Commissioner Rebecca Kelley Slaughter, has correctly pointed out that a number of the Section 18 rulemaking hurdles are self-imposed and not necessarily required by the FTC Act. In my view, there are significant advantages of requiring a restatement rulemaking that covers a broad swath of consumer harms that have already determined to be illegal but don't currently trigger penalties. This common sense restatement rulemaking approach would diversify our toolkit in a broad range of cases to strengthen our ability to deter and correct wrongdoing without imposing burden on honest businesses. For example, the FTC routinely targets so-called imposter fraud, where bad actors impersonate or claim approval by the government in order to trick consumers. We see this practice both by small-time scammers and large corporations, such as a food manufacturer that falsely claimed its products were FDA approved to treat medical conditions. A rule prohibiting this practice would ensure that those wrongdoers face real consequences without burdening honest firms. And in my experience, when the Commission has civil penalty authority, it becomes far more likely that firms can quickly agree to some meaningful redress too. Given the clear benefits restatement rulemaking can confer, I think we should push forward with this soon. That this rulemaking will trigger penalties, damages, and other relief only after it is finalized underscores the importance of getting going quickly. Another key tool for the Commission is administrative litigation. Under the FTC Act, a key responsibility for commissioners is to make conclusions about what's legal and what's not when it comes to specific cases relating to unfair deceptive conduct or unfair methods of competition. You may know that the vast majority of consumer protection actions are brought in federal court, where a federal judge, rather than commissioners, adjudicate the dispute. And undoubtedly, bringing cases in federal court has certain advantages. The Commission can seek preliminary relief and monetary relief and benefits from robust discovery procedures. But administrative litigation has advantages that should not be overlooked. The Commission's unique vantage point as an expert agency allows it to develop specialized knowledge. You may be familiar with the research and studies that we have conducted under Section 6B to really understand and look under the hood of what's going on in markets. That really is important when it comes to emerging business practices and challenge, like dark patterns online, micro-targeted at individual users, or algorithmic discrimination. In cases like these, we might not need to wait for bad practices to infect the whole market and then play catch up. While it is true that under current practice, the Commission does not order monetary relief when it goes through our in-house administrative litigation and issuance of a final order, there are still pathways for recovering money for victims. For example, if the Commission's ruling involved conduct that would reasonably be seen as dishonest or fraudulent, Section 19 of the FTC Act allows us to then seek monetary relief in federal court at the conclusion of our administrative proceeding. Because of the availability of this two-step process, which I admit could take a long time, but we can enter administrative settlements that also include monetary relief, as we recently saw in our Lend EDU matter. In addition, this connects to the penalty offense authority, because those final Commission orders can then bind other market participants engaged in similar wrongful conduct, allowing the Commission to trigger penalties for violations by other parties. Now, in spite of some of the advantages I mentioned, administrative litigation, and for many good reasons, has been rarely pursued. In fact, in my entire time at the Commission since I joined in 2018, we have not taken oral argument in a single consumer protection matter in our administrative forum. I do think the Commission needs to consider how it could modernize our in-house tribunal for consumer protection, particularly when it comes to the digital economy. Currently, the rules and procedures that govern our in-house process are really more suited to a fast merger trial with a compressed schedule that can limit discovery in complex matters. The Commission can think about revising this schedule or make other procedural reforms to make administrative litigation a more viable and efficient option for all parties involved, particularly for emerging practices where the Commission's expertise would be beneficial. The final tool is not really a law change or using a different legal tool. It's really a policy and process change that I think we need to bake into the DNA of the agency. And that's partnering with civil and criminal law enforcement more frequently. In my past experience, I've worked at a number of agencies that enforce the law, and partnership and collaboration is really part and parcel of everything that's done. And the FTC's authorities may be under threat, but there are dozens of enforcers, particularly at the state level, with similar jurisdiction but greater remedial authority. Many of you know I have deep respect for our state attorneys general and regulators, and I seek to stay in constant communication with them. And almost every state, for example, has its own version of the FTC Act, often nearly identical to Section 5's prohibition on unfair deceptive practices and unfair methods of competition. Yet, unlike the FTC Act, many of these states have authority to seek civil penalties and other remedies on first offenses. On major market-moving cases, I fear the FTC too often goes it alone. For example, in a major case targeting fake reviews, the Sunday Riley cosmetics matter, the FTC agreed to settle for nothing, a no consequences order that simply required the company to say they won't break the law again and to fill out some periodic paperwork. But many AGs are intensely interested in the concerns in the digital economy, including fake reviews. And we could have avoided this no consequences outcome by partnering with one or more of them to achieve a better result. State AGs are not the only partners who can help us deliver stronger results. State regulators often have supervisory and licensing authorities at the table, and in serious wrongdoing can even mean revocation of a license. For cases in consumer financial services, there's the CFPB, who can seek penalties for unfair, deceptive, or abusive practices and make available a redress fund for victims of judgment-proof defendants. And for cases involving recipients of federal funds like for-profit colleges, agencies like the Department of Veterans Affairs can help ensure taxpayer money isn't subsidizing fraud against veterans and can facilitate debt relief for the victims. Perhaps most importantly, I think we should expand our partnerships with criminal law enforcement and not just for small-time scammers. Already, we have a criminal liaison unit. Corporate fraud in the digital economy, including in the digital economy, can violate criminal statutes like mail fraud and wire fraud. We can and should do more to refer wrongdoing in the boardroom to appropriate authorities. I think all of us agree that getting the best results as possible for families and honest businesses matters much more than which agency is getting the credit. And just as groups like TINA.org refer cases to the FTC for enforcement, even if it means sharing credit for the ultimate result, the FTC should never be afraid to reach out to our federal and state partners to ensure the best possible outcome for consumers in the market. Now, I know this is a big week, and I know there are many out there rooting against the FTC and hoping that we will lose. They hope the Supreme Court cloud hanging over our agency will cow us into accepting subpar settlements. And they hope we will slink away from challenging misconduct by major firms and instead simply target small outfits less able to defend themselves. And they sure are hoping that there'll be a hasty retreat from our important market moving work. And I believe we can and will prove them wrong. While it is vital the commission and its talented attorneys prevail in the Supreme Court, regardless of what happens, the commission can and should take steps now to diversify our toolkit and ensure we can continue to seek accountability for wrongdoers and compensation for victims. Whether it's initiating restatement rulemaking, designating penalty offenses, reviving administrative litigation, or deepening our partnerships with other authorities, there are tools we should resurrect today to step up our deterrence of harmful practices, including online. By pursuing this path, I really hope the commission can emerge from this moment of crisis stronger than ever. So again, Bonnie, thank you to you and Tina.org for hosting this discussion. I'm really happy to be here and happy to take a couple questions.
Thank you so much, Commissioner Chopra. You've given us a lot to consider. And so I'm very pleased that we have some questions from some attorneys to start us off that have been focused on the FTC's regulatory authority for some time now. And for those watching, after those questions, time permitting, we'd love to take more from the audience. So feel free to put them into chat and we can pull them from there. So to start us off today is, I think, Corbin. Corbin, if you want to join us and briefly introduce yourself, that would be great. Thank you.
Hi, Corbin Barthold. I'm Internet Policy Counsel at TechFreedom. Thank you, Tina, for having me. Thank you, Commissioner, for having me. AMG, of course, takes a narrow definition of injunction as a bar on future conduct. The FTC argues in its brief that injunction opens up the ancillary jurisdiction or cleanup doctrine of an equity court, which is very broad. There is sort of a third way that we see in some of the case law where the Ninth Circuit took a line very close to the FTC's of allowing the cleanup doctrine. The Second Circuit looked to the ERISA case law, which under Section 502A3 allows appropriate equitable relief, I believe is the term. And there's a series of Supreme Court cases that says, well, that can't just mean all equitable relief under the cleanup doctrine, or else there's just surplusage. You would just say all relief. So we're going to say it's traditional equitable relief. And that has caused all kinds of headaches. The court has had to repeatedly go down and revisit what that means. But what I'd like to know is, putting aside the merits and the reasons they wouldn't do this, but if you'll indulge me in the assumption that what if the court flirts with that third option and says, okay, well, we're not going to really take either side's line. We're going to adopt that traditional equitable relief language. That actually could constrain the FTC in all kinds of tricky ways. You mentioned already defendant's gain as an equitable principle as opposed to the plaintiff's loss, but there's others. Joint and several liability might go out the window. You might look, you might no longer be able to get money that's not clearly going to victims. And above all, you might be subject to tracing requirements. It's possible. There's argument about whether you as a government entity don't have to worry about that even under equity. But my question is, if you're subject to those constraints, is that a victory for the FTC? Is that a catastrophe for the FTC? And what will your strategy look like going forward? And just what are your thoughts on that outcome?
Sure, I appreciate the question, Corbin. You know, I do want to allow counsel representing the FTC in the oral argument to address some of that, but I want to directly answer the question at the end, which is, what if the Supreme Court rules in a certain way? Maybe it does not fit, the specific analytical framework that the FTC has outlined, or what AMG's has outlined. To me, no matter what, we need to actually continue to look toward more ways to deter wrongful conduct. And for me, that involves figuring out ways to trigger civil penalties. And I think, I know this, Corbin. I've tried to, hopefully it was clear that all constructions of equitable relief are different than civil penalties. Civil penalties go above and beyond, no matter what that calculation might be. And there is a framework, both in case law as well as in the FTC Act, about how those are calculated. For me, I really have a tough time seeing a lot of the FTC orders or settlements where there's a consumers sometimes get absolutely nothing for conduct that is, in many cases, very egregious. So again, regardless of what happens, not just this Wednesday, but also in any ruling, thinking about the FTC Act and what it affords in terms of Section 18 rulemaking, Section 5M1B penalty offenses, to me is a no-brainer, regardless of what the outcome is.
Well, thank you. And your take on the 5M, your paper's been very interesting, and I've learned a lot. So I won't take up other people's time. Thank you.
Thanks, Corbin. Okay, next up, I think, is Nandan.
Yes, hi, Nandan Joshi. Thank you for having me. I'm with Public Citizen. We are a consumer advocacy organization, and we have filed an amicus brief in the Supreme Court in this case supporting the FTC's position. So my question was, if the Supreme Court does rule against the FTC and says the FTC cannot seek monetary redress under Section 1313, do you see any future role for Section 13 in the FTC's enforcement toolkit? I mean, you mentioned all these other remedies that are out there, other tools the FTC could use, but you didn't mention if there would be any continuing role for Section 13. And particularly, I was interested in how this would impact, your relationships with the state AGs and the other federal agencies like the CFPB, who would still be able to sue directly in court and obtain monetary relief if the FTC were hamstrung in that, if AMG were to win the case.
Sure, and Nandan, thanks for the question. I don't believe that with respect to Section 13B, there is a dispute about the Commission's ability to get an injunction. And of course, injunctions are important. They can halt, or in many ways, we can get preliminary injunctions. Typically, for example, when we challenge a merger, we might authorize a lawsuit in federal court to seek a preliminary injunction before we pursue an administrative proceeding on the merits of the merger. I don't think that's in dispute. And in fact, I regret not sharing more clearly that some of the authorities that I mentioned earlier, they can be used in combination with Section 13B. So and it is done today, the Commission can bring actions in federal court under Section 13B as well as other authorities. So it is no way a substitute for 13B. It, I think, has some possibilities to go more than the existing recoveries we get under the current interpretation, and I hope the longstanding interpretation of 13B, but I continue to believe that the ability to obtain injunctions under Section 13B will continue to be a critical part of what the FTC does.
Great, thank you.
Thank you. I think, John, you're up next.
Okay. Good afternoon, Commissioner, and thank you, Bonnie, for having me. I appreciate it very much. Very interesting remarks, and I have about 8 or 9 questions, but I guess I probably need to limit it to just maybe 1 or 2. I do want to compliment you and Sam Levine on the paper that came out in October. It was really thought-provoking, I think, as we just heard from Corbin, and it'll be interesting to see how that shakes out. But I wanted to ask a question today about Part 3. And you had mentioned that over the years, in fact, we've heard from many commissioners about how administrative litigation is a powerful tool for developing and clarifying the law. I could tell you that when I was a new associate, I was involved in a Part 3 case, and I actually thought that that was going to be my career path. I was going to be a Part 3 attorney. And good thing I didn't pursue that, because I wouldn't be very busy. In 2007 and 2016, we just saw, I think there were 12 cases brought under Part 3, whereas the preceding 9-year period or 10-year period, there were 94 cases brought under Part 3. And I think, as you pointed out, not a single consumer protection case brought under Part 3 during your tenure. Do you envision that we'll see more Part 3 cases regardless of how the case shakes out, AMG shakes out before the Supreme Court? Is that a likelihood, and something that we might expect?
Yeah, I do think that there is an important vehicle, and just for everyone's awareness, when Mr. Villafranco mentions Part 3, he's referring to the in-house way in which the commissioners can issue orders to halt conduct as opposed to going to federal court. You know, many of you know I'm a real FTC history buff, and some of the most important developments in oversight of today's markets, or frankly, markets of the past, were really done through some of the big cases in the Commission's administrative forum. And Congress purposely designed these fora to be a place where a specialized set of knowledge and expertise and experience of doing lots of similar cases in relevant spheres helps create the right set of analytical frameworks that provide greater guidance to the market, as well as how the concept of unfairness and deception can evolve over time. You know, the FTC should be really proud of the fact that many of its administrative decisions and opinions have gone on to really shape law at the federal and state level over time. But again, John, I do think that, you know, I hope that we all can think about, especially those who have practiced in the forum before, how we can think about whether there are ways to tweak or adjust the procedures in order to make it more conducive to appropriate examination and disposition of matters.
Well, thank you.
And just to add one thing to that, you know, there was a very significant change to those administrative procedures. You know, some time ago, one of our predecessors, Commissioner Tom Rush, was very involved in a process of rethinking those. But again, those changes were really in response to trying to truncate administrative merger litigation. And I don't know if we fully appreciated at the time how that might impact the consumer protection docket.
Thank you, John. Okay, next up, I think, is Ted, who I'm not sure if he's joining us via phone or video?
I am on video
Oh, all right.
with the Pacific Ocean behind me because I am coming from California, from the UC Berkeley Center for Consumer Law and Economic Justice. This is Ted Mermin. Commissioner, it's good to see you. And Bonnie, thank you so much for having this session. So Commissioner, a question for you. As I'm a former Deputy Attorney General in the California AG's office a lifetime ago. It seems as though in recent years, the FTC's ability to obtain redress for consumers has fallen behind that of the CFPB, but also many, if not most, state attorneys general. And further, I would say, I mean, we too were among those who filed an amicus brief in the AMG case. It seems not necessarily a partisan issue that it is important to be able to get money back to consumers from whom it has been wrongfully taken. Given the developments of this past week and the election in Georgia on Tuesday, is there a role for Congress in perhaps restoring or developing new authority for the FTC in the relatively near future?
Yeah, thanks for the question, Ted. Beginning in the summer of 2018, the FTC began to hold forums and hearings, including with respect to remedial authority. And I really examined the input on that very, very closely. And it has always struck me, some of you may know that I previously served on the leadership team of the CFPB. And in 2010, Congress went through the process of thinking about the FTC and, creating a new agency. Of course, authorities for all the regulators who had dropped the ball was stripped, put in the CFPB, a more data-driven regulator. But importantly, Congress armed the CFPB with a robust set of tools, including being able to get redress, disgorgement, damages, all the things that the FTC has been getting, as well as a new authority in addition to unfairness and deception known as abusive. So Congress has made that determination in the past. I personally feel that whatever the threat may be to 13B, I just want to underscore this, that achieving deterrence and actually really making consumers whole, I think, requires being able to get a broad panoply of remedies, including civil penalties. So we'll see. I never like to predict what Congress will do or won't do, but time will tell.
Great, thanks, Ted. Next, I think I'm going to turn it over to my colleague, Laura Smith.
Hello, we have a couple of questions from our participants. I'll read you one from Spencer Reese, who is asking you, Commissioner Chopra, do you think that the FTC's penalty offense authority is very fact sensitive?
Yeah, so in the article that the working paper I published with Sam Levine, we reference some of the contours of the authority, and there's not a huge amount of cases we have on this, but here's what I will say in terms of procedure and due process. There are unusually strong due process protections for those who might be liable for a penalty under the FTC penalty offense authority. In addition to being able to challenge liability for the offense that someone is being charged with, they also can challenge the initial commission order that spelled it out as the practice is unlawful in the first place. So I think you asked whether it's fact specific. I can't cite exactly what is said in the statute, but the way I read it is that if someone has knowledge that the commission has said a practice as unlawful and they do the same thing, and again, there is a knowledge requirement, I think that is where, obviously the details matter in this. I will say though that again, there was some great use of it a generation ago. And according to some of the records that we looked at, thousands of warnings were sent with notifications, penalty offense notifications in them, and it was considered, broad and highly successful. So I hope that's responsive to your question, but I think that's really how I approach in thinking whether someone has knowledge that what they're doing is wrong. I will say this too, there are many things that I do think are pretty well known, about things that can't be lied about. I know for TINA.org was really looked a lot at the multi-level marketing industry with respect to income claims, outright lying about income claims. There are a number of past commission orders about that, and I don't think it has to fit the same exact industry, but the practice needs to it needs to be understood that that's the practice, and they have knowledge of the order, and that they're doing the same thing.
Thank you, Commissioner Chopra. And just to piggyback onto that answer, it's a question for me, actually. I'm wondering if, with respect to the actual knowledge component and ensuring that the party at issue has that knowledge, I'm wondering if you think there's room for the notice of a final cease and desist order to come from other entities besides the FTC, such as other federal agencies, state agencies, or even consumer groups like us or others.
That's a terrific question, Laura. And let me be very, very clear. The penalty offense trigger is not predicated upon a formal notification. It's predicated upon knowledge. So I say notifications because that can be a really easy way to ensure that someone has knowledge. There's a paper trail to it. So I haven't thought too much about this, but my sense of the statutory scheme is that knowledge can be created in many different ways, and certainly entities other than the FTC could likely be involved in creating that type of knowledge and potentially triggering penalty liability with those final cease and desist orders that have been entered by the commission.
Great, thank you. I think we have time for one more question. This question is from Stacy Bosley. She asks, Commissioner Chopra, you mentioned criminal penalties. Can you say a bit more about the considerations involved in determining when to partner with law enforcement agencies and seek criminal prosecution in the context of a consumer protection case, and how you would like that to evolve going forward?
Yeah, it's a great question. So the FTC currently has a chief of our criminal liaison unit that already does work in this area. One of the cases during my tenure that I was very concerned about was a no consequences order we issued in a wage fixing matter. It was called Your Therapy Source. And it was about, I'm paraphrasing, but the individuals involved were communicating to essentially fix wages or contractual payments to home health care workers. So the FTC entered into a settlement with the individual, telling them the order requires them to follow the law and to fill out periodic paperwork. There was no money for the victims. There was no notice to the affected parties. There was no admissions or findings of liability. And it just kind of raised questions about when we find conduct that, is so egregious. Not only should we be getting proper remedies, but we should also be determining whether criminal law enforcement is appropriate. Of course, we are not a criminal law enforcer, but in that same matter, last month, the Justice Department did charge the individual with criminal charges with respect to antitrust violations on fixing prices, as well as I believe it was an obstruction of justice charge with not providing accurate information to the FTC. So, there are many factors one considers, obviously an assessment of the conduct to determine whether it violates particularly criminal fraud statutes, an assessment about what is the right way to achieve deterrence. In many cases, there is an unfortunate culture, in my view, of the FTC really going after small outfits, often judgment proof. It doesn't allow there to be much remedy for consumers, and sometimes the individual can stay in business, even though it can look like really hardcore fraud. So I do think there are many ways that we can be thinking about this, but the FTC should be really focused, I think, on major market participants, particularly emerging commercial practices. Of course, policing the market writ large is important, but we are not a criminal law enforcement agency. And I think when appropriate, those handoffs need to be made.
Great. Thank you so much for answering all those questions, Commissioner Chopra.
Well, thank you, Laura, and thank you so much to the whole team at TINA.org. Again, this is an important week, and we will see how it plays out. But my pitch to all of you is that it is really time to look broadly at the FTC's role in policing these critical markets, especially during a time of a pandemic, during a great deal of economic uncertainty. It is not just about, fake vaccines and cures. There are people looking for new sources of income. There are new ways in which people are being baited. And we need to look at what is the most efficient and effective way to make victims whole, deter bad conduct, and to really continue to develop the law and systematically take on that abuse. So I really thank you again for hosting this.
Well, thank you so much, Commissioner Chopra. I could not agree with you more. And I want to thank you ever so much for your time and thoughts today, and to thank all the panelists and those who asked questions. I wish everyone a very happy new year. Stay safe, stay well, and we're going to put up on screen how to stay connected with TINA.org for all the viewers. So thank you again. Bye.
Thank you.